Well, thank you very much, Gerhard Dannecker, for this kind introduction. Now let me first share my screen with you. I hope you can see my screen now. Okay, I will take, ladies and gentlemen, good morning. I will take a broader view and not just cover internal investigations, but rather take a look at the difficulties or different strategies that emerge when defending companies. And by doing so, I will, of course, also cover internal investigations. For several years, the understanding that companies could not afford to defend themselves in a contradictory way has shaped at least the German debate about criminal defense of companies. It seemed obvious that companies would rather pick single employees as scapegoats and to finger point at these individuals than publicly respond to allegations. At least in the view of the current German legal situation, which only allows to implement administrative sanctions against companies, but not criminal sanctions. This view would enable and encourage companies to finger point at their own representatives in the described way. Others, however, including myself, argue that it actually matters for companies to be subject to sanctions at all, no matter if criminal or administrative sanctions, and most of all, to be the subject of media coverage. Regardless of that long-lasting debate, if we take a close look at current criminal proceedings in major cases in Germany, in which companies are playing a role, we can determine three ideal types or three models of the criminal defense of companies, which indicate that there are different ways to defend or represent companies. Now, I am referring to the phrase of ideal types in the sense of Max Weber, and I would like to introduce these three ideal types or different models in the sense of possible strategies when defending companies. We have three models and three different characteristics. We have model A, which I would like to describe as the active criminal defense of the company. And I will come to the three models, of course, more closely in just a second. We have model B, the passive criminal defense of the company, and we have model C, the administrative representation of the company. Let's have a look at the characteristics of the three ideal types. The three models have different characteristics in the way the defense attorneys interact with leaders and employees of the company, as well as with the criminal justice authorities, and last not least, with the individual defendants' attorneys. Let me start with model A, the active criminal defense of the company. Active criminal defense of a company is characterized by the company's formal legal representation in criminal matters. The defense, in this case, informs those outside the company, that is the prosecutor, the judge, maybe even the public, that the company is being represented and will be defended. Active criminal defense means demonstrating presence and taking a position on the case, on the matter. This requires an independent, thorough assessment of all facts, including the content of the prosecutor's files. Active criminal defense may be adversarial or even contradictory in the sense that the defense lawyer will express his factual and legal opinion by submitting defense statements, which is independent of the prosecutor, or which can be independent of the prosecutor's assessment. The defense lawyer will, however, at least in a high percentage of the cases, include the company's corporate compliance, as well as information gained from internal investigations in his statements. He obviously cannot neglect any findings from internal investigations. Notwithstanding the adversarial character in practice, the defense lawyers choose to formally cooperate with the criminal justice authorities. This formal cooperation includes the disclosure of documents, informing the prosecution about the fact that internal investigations are ongoing, and coordinating interviews in the sense of interviews in internal investigations with the prosecutor, and also discussing other steps referring to internal investigations with the prosecutor. Internally, active criminal defense is characterized by a thorough assessment of files and the discussion of its content with the company's persons in charge. If there is a common ground for defense, the company's criminal defense lawyers will discuss the facts and legal implications with the accused individual's criminal defense lawyers. The different counsels might even seek a common basis towards the prosecution. In case of a conflict between the companies and the individual defendants' interests, the company will prepare for possible attacks by the individual defendants' lawyers. Active criminal defense will be chosen if the company's current leaders find or believe that there is a potential for effective defense. Moreover, the company's heads or leaders must not, with regard to their stakeholders and shareholders, as well as with regard to the public perception, fear confrontation. If they do, then they will not choose Model A. Let me now come to Model B, please, the passive criminal defense of the company. In its ideal type, passive criminal defense does not present itself to the outside world in an adversarial way. There is no actual defense in the criminal case towards prosecutors and courts in this model. Communication with the criminal justice authorities is merely formal. The company's defense lawyer does not make a substantial statement, but rather acts as an outsourced company, so-called mailbox. Internally, passive criminal defense is largely comparable to active criminal defense. Facts will be assessed and their legal implications will be evaluated. If there is a common base, the company's defense lawyers might cooperate as far as legally admissible with the individual defendant's attorneys and also provide information or share arguments with them. Passive criminal defense is in particular chosen in cases where a company sees promising approaches for its defense, however, wishes not to go public with an active defense due to reputational risks or other business interests. I will now turn to Model C, the administrative or mere administrative representation of the company. With respect to communication with the world outside the company, the administrative representation is comparable to the passive criminal defense. There is no actual defense. In contrast to passive criminal defense, however, there is not even internal assessment of facts or the legal situation. There is also no substantial communication with the individual defendant's attorneys. This model will be chosen if the company's leaders aim to avoid any procedural conflict due to a variety of reasons, such as to completely leave the past behind, or if the former members of the board, as well as other representatives, have been removed, or in cases of insolvency. Additionally, facts may be assessed in an internal investigation. I will now come to the chances and risks of the three models. It might already have become evident that the three models imply different chances and risks. I would like to present these chances and risks for each model in more detail. And again, I will start with Model A, the active criminal defense. As already mentioned, in current German law, criminal sanctions cannot be imposed on companies and legal entities. Although, and we just heard it in the lecture of Mr. Sackreuter, although a new Corporate Liability Act, Verbandssanktionengesetz in German, has been drafted, it has not yet passed Parliament and is unlikely to do so before the end of the current parliamentary term. However, active criminal defense may address possible administrative fines due to Section 30 of the German Administrative Offences Act, Ordnungswidrigkeitengesetz, as well as the confiscation of assets due to Section 73 of the German Criminal Code, by trying to build a strong position and to submit written statements in the criminal proceedings. Being able to influence the outcome of the criminal investigation is also an opportunity for the company's reputation. On the other hand, reputation risks may evolve from exposing the company through an active criminal defense, especially since the direction of media coverage is hardly predictable. The public might perceive the company as inconvincible of their wrongdoings. I will now turn to Model B, the passive criminal defense. Passive criminal defense may reduce these reputational risks. If there is a common ground for defense, the individual defendant's attorneys may use arguments developed in the company's sphere for their defense. Since the company does not communicate its position to the outside world, in terms of Model B, frictions with internal investigations are unlikely. However, when it comes to negotiating sanctions or negotiating the amount of confiscation with the criminal justice authorities, the company is unable to refer to an own independent legal position, since it has not developed one beforehand, or at least has not communicated one beforehand to the prosecutor. Consequently, the defense will usually have no basis to refer to the benefits of the company's compliance management systems with the criminal justice authorities. I will now cover Model C, the administrative representation. A merely administrative representation of the company is also able to reduce reputation risks. Regarding possible corporate sanctions, this kind of representation is fully neutral, especially in cases where allegations include recent events or even the present. This model could be beneficial. This is especially true if the company and its present, maybe new, managing board wishes to demonstrate its greatest possible distance from the allegations. A mere administrative representation, however, implies risks regarding possible sanctions. The company will not be able to refer to a legal standpoint which it has drawn up independently. Since there is no cooperation with the individual defendant's criminal defense lawyers, there is not even the possibility to be informed about their strategies and to benefit from them. Neither has individual counsel been provided with information or arguments. I will now turn to the interaction of the companies and the individual defendant's criminal defense. As we have seen, the amount of interaction between the companies and the individual defendant's attorneys varies greatly between the three models. I would now like to address these interactions. And again, I start with model A, the active criminal defense. Common ground between the companies and the individual defendant's criminal defense may especially be found if there are promising approaches which argue against any wrongdoing of the company as well as its employees. Drafting a joint position, the companies and the individual defendant's perspective can be mutually beneficial. This is especially the case if the company's arguments and the individual's arguments complement and enhance each other. However, if there are conflicting interests, we have a situation where the company might defend itself at the expense of its employees, who will then be considered to be black sheep, and vice versa. From the company's perspective, in this difficult situation, performant corporate compliance is key. Let's have a look at the passive criminal defense. Passive criminal defense of the company may also find common ground with the accused individual's defense. Since in this model, the company's defense does not address the criminal justice authorities, its perspective may only be incorporated in the accused individual's defense strategy. The company will have to accept that some of its arguments may not be heard in the same way as if the company would be defended or would defend itself in a more active manner. The accused individual's defense lawyers may experience that arguments from the company's sphere, which would be beneficial for their clients, can only be brought up in an indirect way. However, in the case of conflicting interests, it will be in the favor of the individual's defense that the company does not actively defend itself by proceeding against its employees. And finally, I will cover the administrative representation. The mere administrative representation of the company cannot lead to common grounds with the individual's defense counsel. It does not even try to reach such an agreement. Therefore, all arguments from the company's perspective will not be heard at all, not even in an indirect way, by having individual counsel presenting the arguments. Moreover, the company will not even defend itself against arguments on the individual defense counsel, for example, saying that there has been an insufficient compliance management system, or saying that criminal misconduct has been ordered from the top, and thus accusing the company and its board members. I come to my conclusion. My presentation of the three ideal types of company defense does not imply a rating of the different models. However, it should be noted that all forms of criminal defense of a company involve chances as well as risks. Also, any kind of criminal defense of a company will interact with the defense of the individual defendants, even if there is no action at all on a company level. In conclusion, all players need to be aware of these implications when deciding, usually at an early stage, of a prosecutorial investigation, whether and how the company will defend itself against allegations. Thank you very much.